Well, hello everyone and welcome to Roofing Contractors Magazine Best of Success podcast show. We are on location here at the NRCA meetings and so honored to have with me Trent Cotney, partner with Adams Reese. Trent, thank you so much for joining me.
Jill, always good to see you.
So there's been some pretty interesting things happening that we've talked about, Trent, but I wanted you to take a minute and just talk to everybody about subpoenas and what would happen if a roofing contractor or anybody actually in the construction industry should get a subpoena of any type.
Right. So, subpoenas in general are requests for documents, and they're generally sent to non-parties. So if you're not a party to a lawsuit, you receive a subpoena. And there's civil subpoenas, so you may be in a court case and, you get a subpoena. And, the way to respond to that would be to work with your lawyer and produce documents. But where you have to take a little bit more precaution is when you may get a criminal subpoena. So occasionally you will see this, and it doesn't necessarily mean that you're going to be a party or you're a target, but you may receive a criminal subpoena that will request certain documents. And some examples of where you might see this is any kind of executive agency enforcement. So, we see it with OSHA, if there's an obstruction of justice type claim where there's a potential criminal prosecution. The way that you will know that is it will mention that it's from a criminal court, or a grand jury subpoena. And there are certain things that you want to do, right? The first thing is, I always recommend, and I, unfortunately I do get these calls occasionally, is I say, look, I like to think I'm good at what I do, but I'm not a criminal lawyer, right? And I don't do white collar crime. You should hire a white collar criminal defense lawyer that is skilled in working with whatever agency it is that is sending the subpoena. And the reason I say that is, even if you believe you don't have an issue, the fact that you're receiving a subpoena means you may have an issue. So you have to take it very, very serious. The next thing is obviously tell the truth. Recognize that if you are receiving a subpoena, there's a high likelihood that whatever agency that sent that has caused the Department of Justice to maybe send a subpoena, that a warrant has probably already been issued, and they probably have already examined the documents that you may have, your emails, your text messages, your personal emails, right? So what I always tell everybody, just assume they have everything, produce everything that's responsive. Don't withhold anything. Obviously work with your white collar defense counsel, but I'm a big believer in having a third party do e-discovery, go through and produce those documents on your behalf, right? You work with that party to do that, because if you're in a position where you're self-producing these documents and you either intentionally or inadvertently fail to produce a key document, the government's going to come back to you and say, well, you didn't produce this. This is a potential, obstruction of justice charge or some other, kind of concealment on your part. So I always try to follow those steps. Obviously tell the truth, produce everything, cooperate, do what you can, but make sure that you surround yourself with top tier expertise. You need to recognize that even if you aren't involved in a criminal and ultimately charged or indicted with any kind of criminal investigation, just responding to a subpoena is going to cost you tens of thousands of dollars. That is an expense you need to spend. Do not cut corners on this. This is, your life at stake. So that's why I say, pay the good expert to do the third party, analysis. Pay the white collar attorney to assist you with whatever it might be. But the key message, the key takeaway is that if you get a federal subpoena, especially a criminal from a grand jury federal subpoena, take it serious. Do not delay. Do not think that you can do this yourself. Go get help. Make sure that you're protected.
So Trent, let's talk about that third party that you would hire to do this. What do you recommend? How do you go about doing that? And will they know just by looking at the subpoena what they need to execute?
So the subpoena goes through a variety of documents, and generally based on what is asked in the subpoena, you can derive what the nature of the allegations are. So generally, if you're getting a criminal subpoena, that means you're either a witness or that you could potentially be a target, right? So the attorney that you hire normally recommends the third party that you use to do the forensic analysis. Oftentimes, that third party may have been ex-FBI or ex-law enforcement. And they will go through and do e-discovery, which is basically a forensic analysis of your digital documents, performing key search terms and doing all that in an unbiased approach so that, they are producing everything they can. So worst case scenario, let's say something is missed even through that process. You can at least tell, the investigator, the Department of Justice, whoever it is that's sending it, to say, look, this is what we did. These are the steps we took. It wasn't intentional on our part.
Sure.
These are the search terms that we used. We did everything that we could. There's a term, it's called ESI. It's part of a protocol that we do when we have larger cases. We work with opposing counsel to determine what are our key e-discovery search terms. How are we going to do this? How are we going to produce it? What kind of file share service are we going to use? It's very detailed. You can spend, these documents can be 13, 14, 15 pages long, depending on how detailed your case is. So you may have to go through a similar analysis, but lean on your lawyer. That's the answer, is lean on your lawyer. Don't go searching for somebody yourself. Lean on your lawyer, follow the advice of counsel.